You are watching Germantown Municipal Television, your source for everything Germantown.
Hello and welcome to Law Talk on Germantown Municipal Television. My name is Vince Perryman and I'm a local attorney with the law offices of J. Vincent Perryman. Each month, Law Talk focuses on a wide range of legal issues and topics. On today's show, we'll discuss custody relocations. With us now is attorney Brice Timmons, a local attorney. Brice, thanks for being with us today.
Thanks so much for having me.
And this is always a topic that I think comes up in a post-divorce setting or a post-juvenile court setting where one parent decides for whatever reason that they need to relocate. And the rules are very complex as to what you need to do to be able to relocate or what you need to do to be able to prevent the relocation.
That's right, Vince. The reality is this comes up, like you say, mostly after a divorce, but sometimes it comes up during the divorce, and sometimes it comes up even when two parties have never been married and they just have children. But the fact is that we live in a really mobile society, and people frequently move around. You know, 20 years ago, 30 years ago, it was really common for people to be born somewhere, grow up there, go to school there, work there, and retire there. It's not the way it is anymore. Now people regularly move for work, they move for education, they move to get married, they move for all sorts of different reasons. Sometimes they just want to move. And I want to say about 15 years ago, Tennessee passed a statute to sort of address this issue when you've got children. And what that statute says is that when parents are spending substantially equal amounts of time with a child, and we'll talk more about what that means in a minute, but when they're spending substantially equal amounts of time with the child, then you look at what's in the best interests of the children. But one of the things that makes Tennessee different than a lot of other states is that where one parent spends the majority of the time with the child, there is a presumption that that parent should be allowed to relocate. And usually, not always, but usually, we're talking about mom. The statute was drafted, I think, with an eye to a world in which more women were working and they were having to move. I happen to know some of the lawyers that were involved in drafting the statute, and they're very successful professional women. And I think they were really thinking about women like them, and the legislature was thinking about women like them who would need to move for work. You were seeing more female executives at the time that this was happening, and it hadn't really been the case in years before that. So the statute now assumes that if one parent is spending significantly more time with the child, then that parent ought to be able to move unless it's going to be harmful to the child to move, unless it's going to, unless the move doesn't have a reasonable purpose. The move doesn't have a reasonable purpose only in very narrow circumstances. And it's only harmful to the child to move. The move itself can't be what's harmful. You've got to look at something more than just, I'm not going to get to spend as much time with mom or dad after the move. You've got to look at something like the child is going to suffer from some sort of serious emotional problem, or is not going to receive medical care that they need, because you're talking about moving out of a medical market. So typically you're looking at those types of moves. Also, courts will look to see if the move is really vindictive and designed to thwart parenting time. So when you've got a parent who's trying to move just to get away from the other parent, then that type of vindictive move is really going to stop the move. But this is a problem that more and more people face as we live in a more mobile society and people have to move for work or education on a regular basis.
Well, and I think it became, in my office at least, it became a bigger issue as the economy got worse. People were losing jobs. They have sort of a niche career that all those jobs moved out of Memphis and maybe somewhere on the East Coast or West Coast, and having to keep the same lifestyle that they're used to and the child's used to. They needed to relocate for work, to get work.
That's absolutely the case. You see this, so we've seen a lot of mergers in medical device companies and pharmaceutical companies lately. And pretty much every time that such a merger takes place, you end up with basically two people in the same job, and they end up cutting half of that staff. So we've seen a ton of medical device salespeople and pharmaceutical sales reps that have had to move in order to find employment. I mean, I see that all the time now. And sometimes they're lucky and they get to move to Nashville or somewhere that's fairly close to Memphis. But sometimes, and more often than not, they're not, and they may be moving halfway across the country. And that can, you know, if you've got a parenting arrangement where mom and dad have the kid pretty much equally, which is more and more common, as you know, these days, for parents to have those shared parenting arrangements. It really creates a huge problem in figuring out which parent the child is going to live with. You can have massive disputes, and I'll say this, it is by far and away the most litigious part of child custody law when somebody has to move. It almost always goes to trial.
And this is always something that I think about when, in my practice, in asking questions if I'm doing a divorce or custody and visitation arrangement, is I'm trying to think, okay, is there a concern of a future relocation or something of that? Do we need to put something in the document to address that? Or, you know, what, and I guess, and it's hard to determine this because what can you do as far as when you are getting divorced or you're getting a custody arrangement in place to be able to avoid this being so litigious if it comes up?
Well, I don't know that there's really any way to avoid this being litigious if it comes up. And you know, you've known me for a long time, and you know I'm the kind of lawyer who tries to solve problems rather than fight over problems. But there's no creative solution for a 1,000-mile distance. There's no way to solve that problem. And you know, when you have two parents that love their children and want to have a relationship with their children, and you know, factors beyond their control force them to live very far apart, it's almost always very difficult to resolve it. And typically, you know, these are the real tearjerker kind of cases where you'll end up in a courtroom and everybody has tried to come up with solutions and nobody is acting in bad faith and everybody's trying to do what they think is best for their child and they just can't come up with a solution. I've unfortunately had to litigate cases where parents had shared equal time and lived very near, you know, close to each other, had lived just, you know, a few blocks away. So the kid felt like they had two homes, two houses on the same street, and that they could go back and forth between mom and dad's as they pleased, that the parents had, you know, a great co-parenting relationship and had never had a single reason to set foot in a courtroom until one of them had to move for work.
Okay, and that's a great place to stop. When we return, we'll continue our discussion with custody relocations. Please stay with us.
I think someone at my friend's school has this thing called autism. My friend's brother's son has autism. My neighbor's son has autism. My son has autism.
Autism is getting closer to home. Today, 1 in 68 children is diagnosed with autism. That's about a 30% increase in 2 years. Learn more at autismspeaks.org/signs.
Don't worry, 74 people were picked before me in the NFL draft.
To fight childhood obesity, United Way and the NFL are helping kids play at least 60 minutes a day.
Okay, time for the team obstacle course. Yay!
What this place needs is more healthy kids. To get involved or donate, go to unitedway.org/play60.
Now I get it.
You are watching Germantown Municipal Television, your source for everything Germantown.
Welcome back. I'm Vince Perryman, and you're watching Law Talk. Joining us on our show is attorney Brice Timmons, a local attorney with Black, McLaren, Ryland, Griffey, and Jones.
Black, McLaren, Jones, Ryland, and Griffey, but everybody just says Black, McLaren.
All right. And what we're discussing today is custody relocations. So, Brice, before the break, we sort of broad brushed the custody relocations, and we alluded to a shifting burden that occurs. And really the trigger with it is whether or not you have substantially equal time. And I think we realized on our break that the viewers may say, well, what is substantially equal time? So I think that's where we need to start.
Yeah, first of all, courts regularly say, and lawyers regularly say, what is substantially equal time? Because the statute doesn't define that term. It's left open to the courts to do that. And there's been a range of cases. Sometimes, you know, I think most lawyers say that the cutoff is somewhere in the ballpark of 45%, 55% of the time. There are some cases that go outside of that even. However, more and more what you see these days are truly equal parenting arrangements where parents swap week on, week off, or they alternate, you know, they each have 2 days and then alternate the weekends. These types of shared parenting arrangements or equal parenting arrangements are always going to be substantially equal time. If you get outside of that, it's fuzzy, and a court's going to have to decide, and they're going to look at how much time the parents each spend with the kids. And at that point, you absolutely need to consult a lawyer. If you're not sure whether you have equal time, you need to get a lawyer to help you figure it out.
And are we talking about actual time spent with the child or what's in the court order?
So courts have looked at both. There are cases that suggest that the time the child spends in school should weigh in for the primary residential parent, which is what some people call the custodial parent, the parent who's got more time. However, it's pretty easy to imagine a set of circumstances where you could get a court to disregard that if both parents are like equally involved in school and they're really switching up a lot of time during the week. You know, sometimes these custody arrangements get very complicated these days in terms of the schedule. It's not, you know, every other weekend and 2 weeks in the summer for dad anymore. And really, since 2012, when the state of Tennessee made the decision to shift to this idea that each parent should have maximum participation in the life of the child, which is the standard now, the courts have been more and more inclined to award 50-50 arrangements, and parties have been more and more inclined to agree to equal arrangements. And also a couple of years ago, there a whole bunch of psychological studies were finally completed that indicated that this type of shared parenting arrangement really is what's usually in the best interests of kids. That kids turn out better when they're able to have relationships with both parents.
Yeah, and that's one thing that I suggest to all parents. If they are dealing with a psychologist in their case and they put together a report, look at their sites, look at the dates on those sites, because medical reviews, everything's got to be reviewed every 10 years, and sometimes we see folks that they're citing stuff from 12 years ago, as opposed to these new studies.
The old Bible on child custody arrangements was a book written by a guy named Dr. Ackerman, and Dr. Ackerman's book suggested that it was probably not in the best interest of children to have equal parenting time unless the parents got along really, really well. And for 10 years, almost, that was gospel. Well, fast forward to now, and that's not gospel anymore. There are a lot of psychologists working on this. The guru in the field is a woman named Dr. Linda Nielsen. She and her colleagues and the researchers that she's based a lot of her work on have studied the outcomes for children and determined that contact with both parents is real critical to good outcomes.
Yeah, and she did a review of over 40 studies, which is a really good review. And I think her point that she always makes is we have a changing world, a changing society. We have people choosing to have children and remain unmarried, and divorce is prevalent. Whereas those prior studies, prior to 2013, we're talking about war orphans and things like that.
Right. So we live in a really mobile society, which is the whole reason that we're talking about relocation. And it turns out kids are pretty resilient about that sort of thing. And it turns out kids are pretty resilient about relocations too. You know, we live in a society where there's a lot of telecommunication equipment around in everybody's home. I mean, we carry devices in our pockets that allow us to communicate anywhere in the world in real time, face to face. And so, you know, when you talk about a relocation for economic necessity, you know, so that a parent can work, it's not like the kids are never going to talk to the other parent again, or that they're corresponding by letter or something. I mean, this is, you know, this is the modern world, and you can fly just about anywhere inexpensively these days. You know, if you're talking about a relocation even halfway across the country, you know, kids can usually get a round trip ticket on oddball days for, you know, a few $100s. So it's not the end of the world, but it does seem that way to a lot of parents at the time that they're dealing with it. And especially if they've got that equal parenting arrangement, trying to figure out which parent is going to be the best parent and to keep the kid. And I'll say that more often than not, if parents have truly equal time, if the child is doing well in school, they're doing well in their community, they don't have discipline problems, and they're happy where they are, courts are pretty loath to take kids out of a situation they know is good and then move them with the other parent to a new school, a new environment. It's, you know, to really change things up, unless there's a good reason to do so. If kids aren't doing well in school, if they're having psychological or emotional problems, if they're getting into, you know, fights at school, or they're having discipline problems, then, you know, the court might really look at that new community and say, well, let's see if we can, you know, improve this kid's life just by changing things.
So yeah, some talking points for anybody that's wanting to take notes on this, I think, is first, make sure you get substantially equal time, and then make sure you exercise it and you are actively involved in your child's life, as far as involvement in school, making sure they're doing what they need to do, basically being a good parent.
And that's, I mean, that is really the best advice I could ever give any client. Just be the best parent you can be. You know, often when parents are married, one parent will do more parenting than the other, and the other parent's going to have to, you know, catch up. But it's possible. Be the best parent you can be. You should take as much time with your children as you can possibly exercise. And you should try really hard to cooperate with that other parent and work with that other parent to the best of your ability. Be involved in your child's school, be involved in their extracurricular activities. Those are the things that courts are going to look at. And if you've got substantial equal time and you're very involved, the courts are going to look more favorably on you if you find yourself in this horrible situation.
Okay, and when we return from our break, we will talk more with Brice Timmons about custody relocations. Please stay with us.
They're coming. Places, everybody.
Light check. 1, 2, 1, 2.
Everything looks good on our end.
And lights.
Come alive with the forest. Visit discovertheforest.org to find a forest near you.
Looks like it's done.
Don't let salmonella get funky with your chicken. On average, 1 in 6 Americans will get a foodborne illness this year. You can't see these microbes, but they might be there. So learn the right temperature to cook each type of meat. Keep your family safe at foodsafety.gov.
You are watching Germantown Municipal Television, your source for everything Germantown.
Welcome back. With us now is Brice Timmons. We're talking about custody relocations. Before the break, we kind of broke it down as to what substantially equal time is and some of the things you want to do to try and keep a court from allowing a relocation. And I think implied with all of this is there's a shifting burden as to who has the burden of proof if this goes to court. So I guess that's the reasonable place to talk about now.
Right. If you don't have substantial equal time and you are the non-relocating parent and the alternate residential parent, meaning you've got less time, and you want to stop a relocation, you've got to go to court and you've got to prove that the move is vindictive, that it's likely to cause substantial harm to the child, or that the move lacks a reasonable purpose. And just to be clear, a reasonable purpose, moving for better employment is almost always going to be a reasonable purpose. Many courts have found that moving for marriage is a reasonable purpose. Moving to be close to family is frequently a reasonable purpose. Not reasonable purposes would be moving to take a lower paying job that you like better. Moving for some speculative reason, like I'll move and I'll go into business in this place and maybe I'll make a bunch of money. That's not going to likely be a reasonable purpose. I guess it could be, but it would be unlikely. Even once you've proven that, though, if you prove the move doesn't have a reasonable purpose, or you prove that it could be harmful to the child, you then have to still prove that the move is not in the child's best interests. So at that point, once you've gotten past that first hurdle, now the court applies a best interests analysis. And that's a balancing test, meaning neither party, there's no presumption in favor or against relocation. Nobody starts out with the scales weighted in their favor. And the court just has to look at a lengthy list of custody factors and decide what the best situation for the child is. Now, if you've made it to that hurdle and you're the alternate residential parent and you've got a great relationship with the child and the child is comfortable living with you and they're doing well in school again, and we have some of those same factors we talked about, that the home, community, and school record of the child is good, then you stand a better chance of becoming the primary residential parent and keeping your kid there with you. But if let's say you're the parent that desires to relocate, you've got that advantage of having been the child's primary caregiver. And so those are going to be your two big factors. The primary caregiver is always going to have a strong advantage in those types of proceedings, just as a general rule. So that's why it can be very important for those alternate residential parents to be heavily involved in the life of their child, even if they are unable to reach a custody agreement or get a custody order that makes them, truly equal in terms of time.
Right.
I'm not suggesting that some parents are more or less equal than others, but in terms of time, that gives them the equal amount of time.
And I think this is an important point to make too, is a lot of parents are like, well, my child doesn't want to go, but there's always the issue of, at what age can the child talk to the court?
So in my personal practice, I have virtually never had a child talk directly to the court in the form of testimony. At that point, usually what I'll try to do is get a psychologist involved or a guardian ad litem, someone that can represent the child's interests without the child being stuck in the middle. That's a horrible thing to do to a kid.
Right.
But it does need to happen sometimes. But at the age of 12, a court is required to consider the preferences of a child. They have the discretion to consider the preferences of younger children, and I've certainly seen them do so. But the older the child gets, the more weight they're supposed to give to that preference. Very rarely are courts going to make a 16 or a 17-year-old move if they don't want to move.
Right.
They'll listen to a 12-year-old's input, but they recognize that a 12-year-old isn't able to evaluate the quality of schools or their participation in extracurricular activities in the way that older children, teenagers, are going to be able to.
Yeah, and I think I've only had one case in which the child was on the stand, and in that situation it was the judge asking the questions, the attorneys didn't, and that was not an easy thing for anyone, and so you want to think about that before you stick your kid in the middle of it.
Yeah, if you find yourself thinking about placing your child on the witness stand, you need to have a very long conversation with your lawyer and with your psychologist. And at that point, if you're at that point, you need a psychologist involved about whether this is going to be good for the child. Because asking a child to pick between two parents in a courtroom is a horrible, horrible thing. I've never seen it go well. And even when I've seen it not go badly, I've never seen it do a lot of good.
Well, and I think this is another point that I make to the public is you want to make sure you've got an attorney that can work well with psychologists, not someone who, oh, well, yeah, whoever we get as a psychologist is perfectly fine. Right. Because in our profession, what I have seen with testifying experts, whether it be in personal injury or anything, there's a lot of people that they've realized there's a lot of money to be made at this, and quite honestly, their work product is not that good.
Yeah. I always caution people about letting professional witnesses get involved. Certainly there are lots of expert witnesses, expert psychologists, who testify a lot, but they also have clinical practices. They also have experience working in mental health facilities, working with children, and those guys can be fantastic. There are lots of people who a significant part of their practice is evaluation, and that's fine. But when you have somebody whose entire practice is based on going to court and testifying, I rarely consider using those experts. They have a marked inability to be neutral.
Yeah.
With regard to the kind of lawyer that you want to get involved here, you want somebody who's experienced in custody cases. This is complicated stuff, and especially if you're at the point where you've got to get psychologists involved, you need somebody who's got a good deal of experience in that particular area of child custody, doing relocation trials, because they have all sorts of unique features, and somebody who is really familiar with the psychological community, because most certainly, if you're at the point where you're going to trial, you're probably going to have some psychological testimony going on.
Right. So in wrapping this up, the bottom line of it is if you're dealing with a relocation and it's going to get litigated, you need to get an attorney involved as early as you possibly can. Make sure they're a competent attorney and you're able to fill them out on whether or not they've dealt with psychological proof and things of that nature.
Absolutely. And you want a comparison shop, because once you've started one of these cases, they go very quickly by comparison to other child custody matters because of the timetables that are usually involved.
All right. Our time is up for this edition of Law Talk. I'd like to thank our guest for taking time out of his busy schedule and being with us and sharing his thoughts and insights. If you would like more information about Law Talk or any other program on Germantown Municipal Television, please refer to our website at www.gmtvonline.org. Thank you for joining us today, and be sure to join us next month for more discussion on legal topics. Until then, I'm Vince Perryman. Thank you for watching.